Good evening, everyone, and welcome to the session for our first session for constitutional law. Let me just officially welcome you to the session. And colleagues, like I've said, this is the tutorial session and it's our first session for constitutional law. And the presenter for today is Mrs. Kasambara Simpiwe. She's the one who will be responsible for this tutorial session, colleagues, and she has vast experience in terms of law and is his first session today, colleagues. And I hope everything will go well in terms of the learning and everything. And Mrs. Kasambara is an attorney of the High Court of South Africa. She has an LLB, she has a master's and other certificates and postgrad that she has done, colleagues. So we have someone with vast experience. Please engage, please learn from her, and whatever question you are welcome to ask. Mrs. Kasambara, let me officially end the session to you, and thank you.
So as Godfrey indicated, I'll be tutoring and assisting with constitutional law, CSL2601. Okay, colleagues, so just for today's session, this is the agenda that we'll be following. I'll just be doing an introduction to the facilitators for this module. I'll be going through some housekeeping rules so that we can just familiarize ourselves with each other. Then I'll go into the course objectives, curriculum, and learning outcomes of the module, and then we will jump right into chapter 1, which is constitutional law in context. Please feel free to ask questions, jump in at any time, and I'll do my best to answer your questions. If I don't have the necessary information, I will then refer the question to the relevant parties and get back to you in the next session. Okay, so in terms of the facilitators for this module, colleagues, the primary lecturer is Professor Lee Stone, and she is based at the UNISA Tshwane campus. Those are her contact details. And the contact details are also contained in the study guide as well as your tutorial letter. So you can find all of her details there. As Godfrey indicated, my name is Esther Simpiwe Kasambara. Those are my qualifications. I'm an admitted attorney of the High Court, and I'm also currently serving as a divisional director at RSM, which is an audit firm, the legal department there. So yeah, I love the law and law is basically my life. So I'm really excited to be tutoring this module. Okay, so just in terms of housekeeping, as you should be aware, your lectures with Professor Stone are on Tuesdays, and that is from 2 p.m. until 4 p.m. The first lecture, from what I've been advised, was last week. So the second lecture will be tomorrow, and it will be Tuesdays going forward. In terms of these tutorials, colleagues, it's Mondays and Tuesdays from 6 p.m. to 8 p.m. That is the fixed time that we've set aside. If anything does happen, then Godfrey will be communicating with you in terms of rescheduling or things like that. And just to give an understanding or to outline what we'll be doing in these sessions, what I am going to be assisting with is facilitating your understanding of the course content. So it's still up to you to take responsibility for your studies, to go through your course material. I'm just here to assist you in understanding the various concepts related to constitutional law, and to just help you and guide you through the module together with Professor Stone, well, in assisting Professor Stone rather. So as I said, please feel free to ask questions. Please feel free to engage. I will answer where I am able to. Where I am not, I will let you know. In terms of your study material, the primary study material for this module is your study guide and your textbook. Everything you need will be in those two sources, but I would highly recommend that you have a copy of the Constitution with you. whether it's a hard copy or a soft copy that you download online from verified sources. Just ensure that it is up to date. But it just does help you when you are studying to have your constitution on hand so that you can refer to the relevant sections, and you can also just make notes for yourself in terms of the various sessions, so that when it comes to exam time, you don't have to scramble for a constitution, and you don't have to scramble looking through your constitution for important sections that are there. And another important source of study material is case law. Your case law is very important. And as good practice would be, it's not just about reading a summary or the head note of a case. You need to go through the entire case. You need to summarize it for yourself, because most of the time important principles are highlighted in the body of the judgment itself. So it's very important to go through your case law, ensure that you understand the relevant constitutional principles so that you can be able to apply them. And also, it's a good thing that one of the authors of the textbook that we are currently using is actually the lecturer, Professor Lee Stone. So when she tests you on the content, you'll actually know that it's coming from her knowledge in the textbook that she contributed to. So that's also actually quite nice. In terms of study material and sources, colleagues, just an important note, just be very wary of online sites like Course Hero, because we have found in the past, in my discussions with the lecturer, that a lot of students are using Course Hero, and sometimes it gives you information that is not relevant to the South African laws. So you'll find that it's giving you irrelevant information. You end up using that in your assignment or your exam, and then you don't get marks or you get penalized. So it's just important to steer clear of those ones. Just ensure that you are using reliable sources when you do go online. And also, just a warning on ChatGPT and plagiarism. Putting questions into ChatGPT is good just to give you a sense of what you are trying to research. So it's a good guidance tool, but to put a question in and to copy the entire content and use that in your assignments or your exams, UNISA does have quite efficient mechanisms and tools in terms of online programs that can pick up when you've done this. So just ensure that you are using it correctly and you're not just taking the entire content that's in, for example, ChatGPT and putting that in your exam or putting that in your assignment. And then ethics, I cannot stress enough. I'm sure most of you that are studying this module are aspiring to be legal practitioners. Ethics is the cornerstone of our profession. So you cannot engage in things like cheating, engage in things like plagiarism. It carries weight and it carries with you until you are practicing. And even when you're trying to get admitted as an attorney or an advocate, those things do follow you. So just ensure that you uphold the utmost ethical standards in everything that you do, because it is what is expected of you as a legal practitioner, but not only as a legal practitioner, but as a student of the UNISA University. And then just in terms of respect, colleagues, I will respect you. I ask that you respect me as well. Let's just engage respectfully in any engagements that we have. Let's talk to each other nicely and with respect. And I'm sure we'll enjoy these sessions if we proceed on that basis. And then, as Godfrey indicated, I would really like for these tutorials to be interactive. So where I do ask questions or where I do ask you to engage with me, please do so. And to assist you in doing that, it's actually good to read up on the material beforehand. That helps you to actually be able to engage better, and also just being up to date with your current affairs, because yeah, a lot of the things that pertain to constitutional law are actually really related to current affairs and what's happening, such as elections and things like that. Right. Okay. Moving on to the course objectives, curriculum, and learning outcomes. This is contained in your study guide as well as your tutorial letter. So this just basically outlines what you should be able to do once you have completed this module. And in terms of the purpose, it is to locate, identify, and extract the concepts, principles, and rules of constitutional law from a variety of sources. So as we indicated, you have your case law, you have your constitution, you have other legislation that is subordinate to the constitution that you would have to look at. You've got your common law as well. It's important to be able to extract the relevant concepts in terms of constitutional law. You should be able to present written arguments that demonstrate your understanding of the above. You should be able to analyze court judgments and apply constitutional concepts, principles, and rules articulated and developed by the courts. And as I mentioned, in order for you to be able to do that, you need to understand your case law. And unfortunately, constitutional law judgments are quite long because they do have a lot of fluff. They've got a lot of soft stuff. So unfortunately, some of them are very difficult to read. But I would urge you to still read the full judgment, ensure that you understand them. And then you also need to be able to analyze the facts of legal problems, to identify the nature of the problem, explain the appropriate legal concepts, principles, and rules, and correctly apply these concepts, principles, and rules. Very important, especially for the exam. And then in terms of outcomes, you should be able to recognize the obligation of citizens in South Africa to keep the government in check, as well as other institutions of government. You should demonstrate understanding of the mutually supporting relationships between a sovereign state's internal and external utterances, thus ensuring that international law applied by South Africa conforms with the Constitution. You should also be able to identify when the theory contained in the Constitution or other laws do not cohere with practice. So that just concludes the purpose and the outcomes. Okay, then in terms of assessments, colleagues, the assessment plan will comprise a quiz, an assignment, as well as the examination. So all of those will form part of your assessments for this module. In terms of weighting, the assignments will count 20%. The examination will count 80%. So as much as the 20% may seem small, you still need to pass your assignments with at least an average of 40% in order to gain admission into the exam. So still very important to do well in those assignments, get your marks so that you can firstly gain entrance into the examination, but also to assist you in your overall mark. And then the overall pass mark for this module is 50%. In terms of the assignments that you will need to do, all the information pertaining to that I'm advised will be uploaded onto the My Modules website. So just keep a lookout there in case anything has been uploaded in terms of the assignments. But yeah, guys, I think this is one of the easier modules where you can really do your best and you can actually get a distinction if that's what you're aiming for. So do try your best in terms of the assessments. And then moving on to introduction and chapter 1, being the South African constitutional law in context. Okay. So as I said, colleagues, I'm really excited, and I want you to be excited as well about this module. It is one of the most important modules that you can study, if not the most important one, because we're dealing with the supreme law of the land, and that is what the Constitution is. It is the highest law in South Africa and many other countries, actually. So it's quite an honor for me to actually be tutoring this module to you. Colleagues, the lecturer has just advised that I don't know if you have gone through your study guide, but there is a diagrammatic representation of constitutional law on page 6 of the study guide. And if you have a look at that, it is actually a nice summary of the entire module. So if you just need to reference, or if you just need to understand what we're going to be doing in this module, and even when you are preparing for your exam, please just have a look at that diagram. Ensure that you understand it. Ensure that you understand the various spheres of government and all of that. It is contained in that diagram. So that's a nice tip for your exams, to just refer to page 6 of the study guide and ensure that you understand that diagram. Okay, so constitutional law is more than just fundamental rights, so it's more than just the Bill of Rights and administrative law. These are taught as separate modules at UNISA, but constitutional law is more than that. It encompasses these two elements of the Bill of Rights and administrative law, but it is not the only thing that constitutional law is about. And you will see as we go along that there is actually more to it in terms of government and how government operates. So just important to note that when you are studying, you're not just studying the Bill of Rights, or you're not just studying administrative law. So just bear that in mind. And then in terms of the constitution, so what is a constitution? And this is just in general terms in different countries, not just South Africa. So a constitution is a founding document upon which authority of state is premised and establishes the organs, structures of the state or government. It authorizes, regulates, and limits the exercise of power by branches, institutions, and persons. And it provides ground rules for the effective functioning of the state. So as you can see, the Constitution is quite an important document, especially in terms of government and how government is run. And all the rules pertaining to that would be included in your Constitution. And then constitutional law. So constitutional law itself is the law that regulates the relationship between the three principal organs of state, which is the legislature, the executive, and the judiciary. For South Africa, this is regulated within three spheres of government, namely national, provincial, and local spheres. So some other countries are unitary states. They only have one national government, but we in South Africa actually have three tiers or three spheres of government, being the national level, the provincial level, and the local level, all of which have small governments of their own. And then moving on to where this is covered in your study guides. If you look at pages 12 to 28 of the study guide, you will find chapter 1, which we are going to be dealing with in today's tutorial. And very, very important, colleagues, to understand the content of the South African Constitution, or to understand anything actually relating to South African constitutional law, one needs to understand the South African history and the injustices of the past, because you will note that the Constitution has actually been purposefully drafted based on this. It's been based on the injustices of the past and how we shouldn't repeat them, and how we can transform our society to ensure that it is equal, so that we never ever again face discrimination that we did during apartheid. Okay, and then what we have, or what our constitution is termed, is a transformative constitution. And it just goes to what I say, it is aimed at full legal, political, and socio-economic transformation. So it is a transformative document. When you look at it, it's not like any other piece of legislation. So for example, it's not like your company law legislation. It's actually a document that is supposed to improve society as it goes on. And it does that in various ways, which we are going to be discussing in this module. Okay, colleagues, moving on to the historical stages. So as I said, in order to understand constitutional law, you actually need to have an understanding of where we're coming from and why it was necessary to actually develop a constitution like the constitution we have today. So I'm going to be going through the historical stages of South African governance structure and basically how our constitution was developed. And please bear with me, it's it's going to feel like a history lesson. But it is necessary just to facilitate your understanding of the constitution and why things are the way they are. Okay, so going back to South Africa in the earliest days of South Africa, we had our indigenous governance structures, and these were quite informal, colleagues. So this was governance in respect of the Khoisan, being the Cape's indigenous inhabitants, and what they had was traditional African government, which was communitarian in nature, and it was divided into three parts. So you would have a chief who was responsible for central government, you'd have a headman who was responsible for specific wards, and then you'd have a family head exercising leadership over the family. And the chiefs applied living customary law. And the strong feature of this stage in history, colleagues, is that it was very communitarian, as we've said. So, for example, your chiefs would really have to have the approval of the subjects. You know, they would need to be supported by the subjects. The subjects would need to ensure that they are happy with what the chief is doing within reasonable bounds, of course. So there was a lot of support from the community at this stage of governance, and it was quite informal. And then we had the next stage, which was when the Dutch and the English occupied South Africa around 1652. And when they occupied South Africa, they had constitutions which were implemented, which mirrored those of other British colonies, because they were attempting to colonize South Africa. So that is what they introduced in the Cape and Natal. And a British appointed governor was also appointed with extensive powers regarding the approval of legislation and veto powers. And then later on, the Westminster system, characterized by parliamentary sovereignty, was then established. So we will go into what is parliamentary sovereignty. It's a very important concept that you need to know for this module. And you're going to hear me mentioning it now and again. Professor Leaston will also mention it during her lectures, because it is what divides or what differentiates our constitution from other constitutions and our government from other governments. And then we had the Dutch colonies of the Orange Free State and Transvaal, which were governed based on a strict interpretation of the separation of powers. That is another important term, ladies and gentlemen, which we are going to be going in depth into explaining. And I'll be explaining that in tomorrow's tutorial, but it is a very important concept to know for this module. And then the Orange Free State adopted a constitution in 1854 reserving rights to white males only. The Transvaal adopted a constitution in 1858 stating that there would be no equality between colored people and white inhabitants. So unfortunately, we do have to go back to a very painful time in our history, and I think it's still painful for a lot of us, especially for some of our parents who actually went through it and they suffered through apartheid. But it does give us context into what the Constitution is trying to achieve. So what we see here is traces of what started as apartheid before it was fully implemented, when power was basically given to white males. Even white females had limited power. So that's where we can start to see apartheid coming in, but it wasn't fully entrenched at this stage. And then constitutional law and practice was based on racial citizenship. And we're going to go more into this concept on how certain people were entitled to vote, so you can understand what we mean by racial citizenship. Okay. And then moving on to colonization in 1894, colonial governments became the primary source of the traditional leaders' authority. This onset apartheid and the Glen-Grey Act was passed in 1894. So what this act did, colleagues, is that it introduced areas where Africans should stay if they're not working for white-owned institutions. And what this essentially did is that it dispossessed a lot of Black people of indigenous land that they owned. And it excluded Africans from parliament, and it weakened the authority of chiefs. So what this act set out to do was slowly to start gaining land from Black persons, but also we can see that there was exclusion in terms of your traditional leaders. Remember, we spoke about there being traditional leaders and African government. What started to happen is that that authority that the chiefs had, that the other leaders had, it was taken away slowly, and they had to submit now to the colonial government. And then what happened next was the Anglo-Boer War. I'm sure we've all heard of it, with where Britain was defeated. Well, sorry, where Britain defeated the Boer, and the British took over government and facilitated negotiations excluding Black persons, and thereby forming the Union, what was known as the Union of South Africa. And then in 1903, we had what was termed the Langdon Commission, or the Native Affairs Commission. It is known by both names. And this developed the idea of a system based on territorial segregation. So it basically entrenched what was contained in that Glen-Grey Act that we see in 1894. And Black and white persons were basically separated, and Black people were given what were called Bantustans, which were their specific locations that Black people could reside. So you couldn't, for example, be seen in town if you were not working for a white-owned business, or if you were not working for a white person. You had to stay basically on your side of the fence. And that is how the land was distributed, and that is how apartheid basically started, by that type of division. And then in 1910, we had what is termed the Union Constitution. This was one of the first constitutions in South Africa. And it brought together the 4 settler colonies, namely the Cape, Natal, Orange Free State, and Transvaal. And these were 4 provinces that formed part of a unitary state. And remember, I explained that a unitary state is one that just has one national government. So all the power is just concentrated at national government level. So this is what happened in 1910 when the union was fully established. And then there was a limited parliamentary democracy, which was adopted, where only white men could vote. So again, we're seeing the exclusion of white women, we're seeing exclusion of all other races from voting, essentially. And then we've got our indirect colonial rule, which was a stage that took place in 1927. The Black Administration Act was adopted in this year, with the effect that the authority of chiefs was legally subordinated to white government. So before, they just started to move into these areas, dispossessing indigenous land and taking the authority of the chiefs. But then they actually also passed a law. They passed an act that actually stripped the power from your local leaders, from your tribesmen, from your chiefs. And they had to submit themselves basically to the Governor General, who had a right to create and divide tribes and appoint chiefs and headmen. So, for example, if a specific community in Natal were wanting a specific person to be their chief, and they voted for that person to be their chief, that person actually could not be appointed unless the Governor General approved of it. So that power was vested in the Governor General, who basically had the final say in who was appointed as chief. That had to be approved. And then we go to the period, the long period between 1936 and 1948, where apartheid was actually implemented in full force. And in order to do that, colleagues, they removed African voters from the voters' roll, because obviously if you remove someone from a voters' roll, they're not entitled to vote, and therefore they cannot have a say in the laws of the country. They cannot have a say in who's in government. So this was basically stripping people of their right so that they could not interfere with this new dispensation of apartheid that was being implemented. Once you take away someone's vote, you take away their right to participate in democracy. And I do hope that we all voted, all of us who were able to vote. I do hope that you voted, because that is how you participate in your country's democracy, and that is how you have a say in government, by exercising your vote. And I do hope that you appreciate that actually the right to vote is something huge. It's something that our forefathers were not entitled to. So I do hope that you did participate and you did vote, and I hope that you'll continue voting in future, because that is how you exercise your democracy ultimately. So going back, the National Party won the 1904 parliamentary election on the basis that it would implement absolute racial segregation. And parliamentary sovereignty became dominant. Okay, so as I said, I am going to be explaining this term of parliamentary sovereignty, but maybe just to give you a brief understanding. Parliamentary sovereignty just means that Parliament is sovereign, so they've got absolute power to make any law that they want, regardless of whether it infringes on people's rights, regardless of whether it is discriminatory. Parliamentary sovereignty is just the principle that Parliament is sovereign. And obviously, if you are voting for, if you are having a parliamentary election and you vote certain people into power, those are the people that will actually be able to pass laws. So parliamentary sovereignty was necessary actually to implement the apartheid dispensation. Otherwise, it wouldn't have been possible, because you would have had to look at people's rights, which the then parliamentary government did not do. And then we are continuing with the historical development. In 1955, the ANC developed what is known as the Freedom Charter. I'm sure many of you have heard of it. And this was just in response to the deprivation which was inflicted on Black South Africans. They were basically responding to this discrimination that Black people were facing. And what the Freedom Charter was, colleagues, is a statement calling on the equality of the inhabitants of South Africa and indicating that the people should govern, the people should have a voice. Every inhabitant of South Africa should basically be treated equally. And it was a very powerful document. It is being displayed in some of the museums. So when you do get a chance, just have a read through that so that you can understand what ideals the ANC was putting forward. And it would also be interesting to see if some of those ideals are still what the ANC live by and still what they are practicing today. So that was the Freedom Charter. And then the period during 1951 to 1957, colored people were removed from the common voters' roll. So this was a step further in implementing apartheid, ensuring that colored people could not vote, because if they were able to vote, then obviously they would have a say in some of the laws that were being passed. And that is not what the apartheid government was wanting to happen. And this was challenged. So this was challenged in the case of Harris and others versus Minister of Interior and another, but the validity of the act was actually later upheld in the case of Collins versus Minister of Interior. So have a look at those cases when you are able to. And then we get to 1957. 59, where there was the promotion of Bantu self-governing territories. So there was basically systematic division of South Africa into self-governing territories known as homelands. There were 10 homelands actually, where only African people could participate politically, and that was in respect of appointing chiefs. But again, this was limited because chiefs would have to pledge their allegiance to the national party. When they pledged their allegiance, then they would assume half of the seats in the legislative assembly of each homeland. So I don't know if we know the homelands, but if you do remember from your history, if you did take history, that was Transkei, Bophuthatswana, Ciskei, Venda, Gazankulu, Kangwane, KwaNdebele, KwaZulu, Leboa, and Xwexwa. So those were the previous homelands that were established during this period, and that was the only place actually where Black people could actually participate to a limited extent in some form of parliamentary platform. Okay, then we get to the Republic of South Africa. So in 1961, South Africa declared independence from the British Empire, because remember when the British won the Anglo-Boer War, then South Africa became a colony of Britain. So in 1961, South Africa broke away from being a colony, and they declared independence, and they became a republic. And a new constitution was adopted during this period, confirming the supremacy of parliament. So we didn't see much change at this stage, colleagues, in the constitution. It basically still assumed the Westminster style of government. The only difference there was that now South Africa was not a colony anymore. So there was still a promotion of parliamentary sovereignty, meaning that Parliament was the sovereign legislative authority with full power to make laws of the Republic. And as I said, parliamentary sovereignty was necessary in order for apartheid to survive, in order for apartheid to proceed, because once you take away someone's vote, then they cannot vote in government, and government can do as they please, and they can develop laws that are even discriminatory. So, as I said, just bear in mind that definition for parliamentary sovereignty, very important. Okay, then moving on to UN conventions. So, ladies and gentlemen, colleagues, the UN was observing, the international stage was basically observing what was happening in South Africa. They were observing the injustices, they were observing the discrimination, and the UN actually responded to this. And they did this by adopting declarations, resolutions, and conventions. This was done in 1960, 1962, 1970, and 1973. And what they were basically calling on was for power to be transferred to the people without discrimination. So they were basically saying, South Africa, you need to have an equal society. You cannot have power just vested in a specific race. You cannot just only have white men voting for a government that is supposed to govern people of various races. They wanted every race to be able to participate in democracy, and that is what they were calling on. So they were requesting member states to break off diplomatic relations with South Africa. They did this to apply pressure to South Africa. They invoked self-determination and ultimately sanctions and arms embargo. So this placed the apartheid government under considerable pressure, because you can imagine if South Africa was not able to export, import, they were not able to participate on an international stage, that actually made them quite weak, and it weakened their position. So the UN interventions to an extent also helped in speeding up the constitutional development, constitutional dispensation that we are actually living in today. And that is one of the important factors of having an international organization or being part of an international organization, because it can put pressure on individual member states to actually change the way that things are done in their countries. Okay, then moving on to 1983, colleagues. South Africa developed a new constitution. This constitution, according to the apartheid government of the time, it was sort of what they were thinking is an olive branch. So what they were essentially trying to do was to try and show that they were enabling certain members of society to actually participate, which wasn't the case. And it didn't work very effectively. But essentially what they did is that they incorporated colored and Indian people in the political system, well, they allege that they did, by creating a tricameral parliament comprising separate houses of parliament. So you'd have one house for white people, one house for Indians, and one house for coloreds, nothing for black people. And the jurisdiction of each house was separated into own affairs and general affairs. So own affairs were issues that were affecting the specific house. So if there was an issue that was affecting the Indian community, for example, that would be dealt with as an own affair. And then general affairs, which were not own affairs or which were affecting the countries generally, those are the ones that would be dealt with as a general affair by all the houses of parliament. Thank you. Okay, they've muted. Okay, thank you for that. Yeah, so as I was indicating, so you had a tricameral, which means, well, tri means three. So you basically had a three-house parliament, which was considering laws, and it wasn't very effective, as I said, because it still excluded black people. So it didn't do much, and it didn't last for very long as well. And then we move on to the negotiating of a democratic South Africa and the establishment of CODESA. So due to international pressures, due to how basically South Africa was sitting on the brink of a revolution, there was pressure from all sides. There was pressure internally from strike action from the ANC and other organizations, as well as the international community. The apartheid government actually decided to negotiate a democratic South Africa. So in order to do this, the National Party and the ANC negotiated a wholly democratic constitutional dispensation from the mid-1980s. So you can see that was shortly after this, the previous constitution was established, and I think they could see that it really wasn't effective, it really wasn't working. So they established CODESA for purposes of negotiating a new democratic dispensation, and this was established in 1991. But CODESA, unfortunately, wasn't very effective. They were taking very long. The people got impatient. People wanted democracy, and they wanted it very soon. So we had what we then call the multi-party negotiating process, or MPNP, as it is called in short, after CODESA lapsed in 1992. And the MPNP was actually quite effective, and it ultimately resulted in the adoption of the interim constitution. So the interim constitution was adopted before the final constitution was put into place, just as an interim measure until the constitution could be finally adopted. And the interim constitution was adopted in 1993. It was adopted or ratified by the apartheid parliament in terms of the 1983 constitution, which is very ironic, because when you think about it, an apartheid parliament is actually now adopting a piece of legislation which is actually ending apartheid. So that was a very interesting time in South African history. And this interim constitution became binding after the 1994 election. And then a coalition government was formed, which would operate for 5 years, and then a constitutional assembly would draft the final constitution after the first democratic election. So, colleagues, the interim constitution was very important because it established some of the pillars of our democracy that we look to today, and some of the very important features of the final constitution. And these include establishing the Bill of Rights, which is the first part of the constitution. And it entrenches the rights of all inhabitants of South Africa. It created a constitutional assembly to draft the final constitution, and it also established, colleagues, what we term the Constitutional Court. I'm sure all of you have heard of it. It is the highest court in the land. It is in Constitutional Hill in Braamfontein. If you haven't visited the Constitutional Court, you should definitely do so. It is actually built on a former women's prison, so it has a lot of historical sort of artifacts. There's a museum there that you can go and have a look at. So it was very intentional, actually, that the Constitutional Court was built on a historical site like that. And it just reiterates the position or the principle that the South African Constitution was actually built considering our historical injustices that we faced in the past. Okay, then the certification of the final constitution. Colleagues, this was done in 1996. The Constitutional Court assessed the text of the Constitution, which was drafted, against constitutional principles, and they did this to firstly determine whether the basic structure and the premises of the text comply with constitutional principles. So here, the first leg of the test, they were just looking from a general perspective. Does this constitution as a piece of legislation address constitutional principles? Then the second part of the test was to determine whether the substance of it and the details of the text comply with constitutional principles. So at this level, they took a more detailed look at the text of the Constitution to determine whether it is actually addressing constitutional principles. And this then culminated in the first certification judgment. And the first certification judgment, in considering the Constitution, found that the text of the Constitution actually failed on the second test. So it passed on the first part of the test, but when they took a better look or a more detailed look at the test to establish whether it complied with constitutional principles, it failed there. So it was sent back to this Constitutional Assembly so that they can fix those specific provisions that were not in compliance with constitutional principles, and then it was sent back to the court, and then the court issued the second certification judgment, which basically certified the Constitution and confirmed that the Constitution was in order and it could be implemented and passed as a law of the country. And that is how we actually get to the current dispensation where we are now, the Constitution that we are sitting with now, colleagues. It has gone through rigorous testing to ensure it's fit for purpose and that it does address the injustices of the past and creates an equal society. Moving on to the characteristics. So we've completed the history of how the Constitution was developed, how governments in separate or in different phases of our history operated. And now we get to the characteristics of the current Constitution, colleagues. So in terms of the citation, you will note that the Constitution actually doesn't have an act number. So, for example, if you look at, I'm going to make an example of the Companies Act again. It's the Companies Act 71 of 2008. The Constitution does not have an act number. And the reason for this is that its status is elevated. So its status is elevated as the supreme law of the land, and by giving it an act number, it would have been considered as just another act. But the intention there was firstly to elevate it to the supreme law of the land. And then also another reason why it doesn't have an act number is that it was not passed through the ordinary methods that it should have been passed under the laws of the time. So because it didn't go through that process, it went through a different process and it had to be certified by the courts, then it didn't receive an act number. And then the characteristic of our constitution, colleagues, is constitutional supremacy. So this eradicated parliamentary sovereignty. So these two terms, colleagues, I'm going to NB again. You need to understand the difference between constitutional supremacy and parliamentary sovereignty, because those are two opposites of each other. So as I explained, parliamentary sovereignty just means that Parliament is the highest lawmaking authority. It can pass any laws. It doesn't need to comply with any constitution. Parliament basically just has authority to pass whatever law that it wants to pass, whether it's discriminatory or not. And that is why parliamentary sovereignty was needed in order to implement apartheid. But in contrast to this, constitutional supremacy is based on the ideals or based on the principle that any law or conduct that is inconsistent with the Constitution is invalid. So if Parliament intends to pass a law and that law is actually discriminatory to a specific person, or it infringes the rights of a specific person, then that law would be invalid, and it goes with conduct as well. Any conduct which is inconsistent with the Constitution that is exercised by Parliament or exercised by the executive, it is actually invalid if it goes against the Constitution. Yes, so ladies and gentlemen, the citation, what I was explaining there is that you will note that the Constitution does not have an act number. So the Criminal Procedure Act, for example, has an act number. I think it's Act 50 something. The Companies Act has an act number, that's Act 71. The Labor Relations Act has an act number. So all these acts, you will note that acts that have been passed by Parliament have an act number attached to them. And that is because when Parliament is in the process of making laws, they will need to identify a specific piece of legislation with reference to a number and a year. That's why, for example, you get Act number 71 of 2008 or Act number whatsoever of a specific year. But the Constitution itself does not have an Act number. And the first reason for this is that it is the supreme law of the land. It is the highest law in the land, so they're basically giving honor, or they're basically giving it prestige by not giving it a number, because it is not like any other piece of legislation. It is actually, every other piece of legislation is actually subordinate to the Constitution. It is lower than the Constitution, and it has to comply with the Constitution in order for it to be valid. And the second reason was that it was not passed through the ordinary methods. So it went through certification judgments where your constitutional court judges had to go through it and see if the content is appropriate, it upholds constitutional principles. No other piece of law, or even in the current day, no other piece of law would actually go through that entire process. So that is why it fell foul of an act number. That is the second reason, because it didn't go through the normal processes that it would take to legislate a piece of legislation. Yeah, I hope I've answered your question, Cynthia, there in terms of why the citation is different. And then, yeah, just going to constitutional supremacy. Here I emphasized, colleagues, that you need to understand the difference between constitutional supremacy and parliamentary sovereignty. So parliament sovereignty is what I've mentioned before. It basically means that Parliament, which comprises the National Assembly and the National Council of Provinces, is the highest law-making body. So the principle basically means that Parliament can pass whatever laws it wants, regardless of whether they infringe on anyone's rights or not, whether they are discriminatory or not. Parliament basically just has full power to make laws. And that is what we had during apartheid in order to make apartheid possible. Um, but what we have today in terms of our current constitution and in terms of our current democratic dispensation is that we've got constitutional supremacy. So that basically means that the constitution is the highest law in the land, firstly. And so any other law needs to comply or needs to adhere with the constitution. Otherwise, it will be invalid. So for example, if they pass a new labor law and it is discriminatory, for example, towards pregnant women or towards people of a specific race, that is not going to be valid because it is not in compliance with constitutional principles, which says everyone is equal and no one should be discriminated against. So we've got constitutional supremacy now in this current dispensation, and that essentially means that any law or conduct and conduct which is carried out by the other body, so for example the executive, the president, any conduct that is undertaken by him, it needs to comply with the constitution, otherwise it will be invalid. So that is the principle of constitutional supremacy. The constitution is basically supreme and everything has to comply with it. All laws, all conduct, or exercise of public power has to comply with the constitution in order for it to be valid. Okay. And then another characteristic, colleagues, is that South Africa is a sovereign state, and it is founded on human dignity, equality, freedom, non-racialism, non-sexism, and universal suffrage protected by a Bill of Rights. So we've now got a Bill of Rights which actually protects the rights of South African inhabitants. And yeah, that ensures that rights are not infringed. It ensures that no one is discriminated against. Otherwise, their conduct will be invalid. And then we've got the rule of law. And what this essentially means, colleagues, is that no one is above the law. Even the state itself, even the president himself, even ministers, even judges themselves have to comply with the law. They cannot do as they please because they are part of government. Everyone is bound by the law, and that is what is essentially meant by the rule of law. That is a concept that we're also going to go further into tomorrow, just to understand the characteristics and where it came from. And then we've got a democratic multi-party system with free and fair elections regularly, which is something that was basically non-existent for other races during the apartheid dispensation. So it was very important for them to include this element to ensure that everyone is entitled to participate. And it's a very important element of our constitution currently. That's why I keep saying, please, if you are able to vote, please do, because that is actually how you uphold your constitution. That is how you exercise your democracy as a South African citizen. And then we've got an independent judiciary. That just essentially means, colleagues, that the judiciary shouldn't be influenced by political powers. It should be unbiased, it should be objective. So, for example, if a specific minister or if an individual is in parliament is conducting themselves contrary to the constitution or they've committed an offense, their matter should be dealt with on an independent basis. The judge cannot be influenced merely because ANC, for example, is the party that is in government and therefore certain people cannot be prosecuted. No, what we mean by an independent judiciary is that the judiciary shouldn't be influenced. The judges shouldn't be influenced. They should act without fear or favor, and they should be unbiased and objective. And objective when they are actually adjudicating matters. And then we've got the separation of powers. Those of you who have studied politics will know this concept of the separation of powers, but I will also be going into it in depth um, in tomorrow's tutorial. And the separation of powers, in summary, colleagues, just basically means that government needs to be separated into three. You need to have a legislature, you need to have a judiciary, and you need to have an executive, and these need to be able to exercise their own separate powers and be responsible for separate powers and exercise checks and balances on each other to ensure that no branch of government is abusing their powers. So it just basically means that government power is divided into three to ensure that no branch of government can abuse their powers, and so that the branches of government can check each other. For example, Parliament would be checking the executive, meaning Parliament would need to look at the conduct that the president and the cabinet are doing. They expect explanations from the president and the cabinet. You will hear of what is called question time. This is where ministers and the president would actually present themselves before Parliament, and Parliament would seek explanations on various things that have taken place. And then we've got the transformative characteristic of the Constitution that I explained earlier. It basically means that the Constitution, colleagues, is a living document. It is intended to improve society as it goes along. It is intended to cure or eradicate the injustices of the past. So it's not like other legislation where it basically just describes the law and what needs to be done. No, it's got values that need to be upheld in order for us to live in a just and equal society. So it is a very powerful piece of legislation, and that is why it is the supreme law of the land. And then another characteristic is that it is post-liberal. So what this essentially means is that it is identical to the constitution of liberal democracy. So for example, our South African constitution has drawn a lot of its content, its structure, its principles, its values from the German constitution. And that actually worked well because the Germans, as you would remember, had a time in their history where the Nazis ruled in government and Jewish people were basically treated badly. Their rights were infringed, they were killed. Thousands and thousands of them, if not millions, were killed during the Holocaust, during those periods in history. So we actually were able to get quite a bit from the German constitution, which would work for us because we've both suffered a form of apartheid, which we are trying to remedy. So that is essentially what is meant by our constitution being post-liberal. It just means that we draw on the lessons, or we draw on the constitution of other democratic states or other democratic countries in order to make our constitution work. Okay, and then moving on to unique attributes of our constitution. So our constitution is often described as having social and substantive conceptions of equality. And this means that we can actually exercise our rights meaningfully. It means that we don't just have a constitution that says that we are entitled to certain rights and freedoms, and then we're not able to exercise them. So this concept actually means that we are able to exercise our rights, the rights that are entrenched in the Constitution, in the Bill of Rights, and those can be appropriately exercised. And then it also places affirmative or positive duties on the state. And what is meant by this, colleagues, is that the state or the government, it doesn't only have a duty to refrain from infringing on your rights, infringing on my rights. No, it actually has a positive duty and a positive obligation. And what is meant by that is that it actually has to play an active role in promoting the rights of citizens. For example, government needs to play an active role in eradicating poverty. They need to play an active role in ensuring that people are able to exercise their rights of freedom, their rights to equality, um, their various rights. So what we have there is that we don't have a passive sort of duty on the state. We don't have a passive government. It has to be active. It's actually got positive obligations that it has to adhere to in terms of the constitution, which is very important, because in order for a constitution to work, the government actually has to be actively involved in its obligations in implementing the constitution. And then another unique attribute of our constitution, colleagues, is that it is horizontal. And what I mean by that is that you have the duty not to infringe on my rights, and I have the duty not to infringe on your rights. So it operates at the same level. It operates between us who are at the same level, but not only us at the same level, it also operates between the state and its subjects. So the state has a duty not to infringe on your rights. That is a vertical line. So that is down and up. But also we as citizens have duties not to infringe on each other's rights. So for example, I cannot just go and assault someone. I cannot just go and hit someone. I cannot just go and dispossess someone of their property, because that is infringing their rights. And I've got a duty, you've got a duty, all inhabitants of South Africa have a duty in terms of the constitution, actually not to infringe on the rights of other people. So that is what is meant by our constitution applying horizontally. That's at institutions or individual persons or natural persons at the same level. And then we've got participatory governance. And what is meant by participatory governance is that citizens are actually able to participate in decision making at all spheres of government. And how do you do this? Once again, exercise your vote. So you will note that in South Africa, we've got local government elections, we've got the provincial and national elections, so that you as a citizen are able to participate at all levels or at all spheres of government, to ensure that if you want a specific party to govern Gauteng, for example, you're able to have a voice and to actually cast your vote in favor of that specific party. Or if you want the EFF to govern at national level, or the DA, or whichever party you affiliate yourself with, then you can have a say at national level as well. So it's a far cry from what happened during apartheid, where only a select few people who were actually the minority in South Africa were able to cast their votes, which was white men. Now every citizen, as long as you are a citizen, you can participate in the governance of the country by casting your vote. Sometimes legislation is also published for public comment, and that enables people to give their feedback. So we have a highly participatory governance system in South Africa under the current constitutional dispensation. And then lastly, another attribute, a unique attribute, is multiculturalism. And this embraces the concepts of Ubuntu and the right to be different, and this is quite unique. A lot of countries have it as well, but you'll find that there are a lot of countries where, for example, 90% of them are one race. And they don't face the same sort of difficulties that we do in South Africa, or that we did in apartheid times. But South Africa has very different people. We call the rainbow nation. There are people who speak different languages. You've got people, all colors, shapes, and sizes. People of different sexualities. People who consider themselves different, and the Constitution upholds all of their rights, and that is what we mean by multiculturalism. That we're embracing the spirit of Ubuntu, where every person has the right to be different. Provided, of course, that you are not infringing on other people's rights. So that is a very unique feature of the South African Constitution, and it was implemented particularly because there are so many different people in South Africa. Okay, ladies and gentlemen, we come to the end of the content part of our session. What I'm going to be doing now is basically just testing your knowledge. So please engage with me. Please answer the questions that I'm asking so that I can see where you are struggling or where I need to explain certain concepts a bit better. This will just also help you in terms of your exam preparation, your assignment preparation, so that we can see where you're at. Okay, so I'm going to ask these questions. Anyone can answer. Once we get the right answer, of course, then we'll move on to the next question. So please participate so that we can see where your knowledge is at. Okay, so the first question is.
I'd like to answer the first question.
I love it. I love eager people. The organs of state.
So as in the first, I think, slide, you mentioned that the organs of the state would be the legislature, executive, and the judiciary.
Yes, 100%. Those are the organs of state. You will also hear them being called the branches of state or the branches of government. So don't get confused between those two names. It is referring to the same thing. So yes, that is 100% correct, Kanya. Those are the organs of state.
Thank you.
Yeah, the second question.
Uh-huh.
I think the 3 spheres of government is the national government, the provincial government, and the local government.
100%. 100%. Thank you. That is 100% correct, colleagues. The 3 spheres of government are national, provincial, and local, and that has actually been done to also avoid abuses. So they've split government into 3 to ensure that these various spheres of government can check each other and can address issues that are also specific to them. So yes, 100% those are the spheres of government. Okay, third question. What is the difference between parliamentary sovereignty and constitutional supremacy? I mentioned this, I think, about 5 times, saying NB, NB, NB. So who would like to answer this one?
I would like to try. The parliamentary sovereignty is it's more like the government, they get to do as they please. It can pass any laws. And it is the highest making law.
Mm-hmm.
And the constitutional supremacy, it's any law or conduct that is inconsistent. It is that is inconsistent with the constitution. It is invalid.
Okay, I'll give you 90%. You know why?
No.
So in the first part of your answer, you said the government can pass any laws.
The parliament.
So you've got, okay, now you've got your 100%.
Oh.
Now you've got your 100%. So yes, now you are 100% correct. So the difference between parliamentary sovereignty and constitutional supremacy is, as Gloria has told us, in parliamentary sovereignty, Parliament is able to pass any law they like. They are the highest lawmaking body, so they can pass any law regardless of whether it is consistent with the constitution or not. And in a constitutional supremacy, the constitution is supreme, and as Gloria told us, therefore every law and all conduct has to comply or adhere with the constitution in order for it to be valid. Okay, great stuff. Okay, then the fourth one is more of an opinion type question that I want to hear from you on, that I want to hear from you on, colleagues. Sorry, my word order was wrong there. Do you think basing the constitution on South Africa's history has actually been effective in eradicating the injustices of the past and creating an equal society today? Or do you think that doing that actually wasn't effective, not effective at all, not effective enough? Do you think it was very important for us to base the constitution on our history in order to have an equal society today? And do you think it has worked? Do you believe you are living in an equal society? Do you believe the injustices of the past have been eradicated? What is your view? Please let me know. There's no wrong or right answer to this. I just want to know what your feeling is.
I think it has been eradicated at some point, because we now in the same umbrella, as much as it does not benefit everyone, but at least the constitution has made way that that allows people to experience things and to allow people to understand that no one is above the law, no one can just do as they please, as much as there's corruption and stuff, but it makes it a bit better than it was before. And then we all together now, part of you know.
Okay, so what you're saying is it has been effective. It's not perfect at the moment.
Yes.
Yeah. Okay. No, yeah, I tend to agree with you. I tend to agree with you that it's not perfect, but it's actually a far cry from where we were before.
Yes.
Agreed.
I seem to think that it's still a work in progress, given the recent high school cases that have happened recently. I believe that it is really still a work in progress.
Sure, your speaker is a bit foggy. Can you please just repeat that?
Okay, I think it's still a work in progress, given the cases that have happened. I believe that it's done.
Okay, so when you're saying it's still a work in progress, and what areas do you think need work? Which areas do you think are not where they should be? When you say there's a work in progress, which areas would you think need to be improved?
I'm referring to the recent racial cases in high school. I don't know. Okay.
Okay. All right. That's a very, very important view. It is a work in progress indeed, and I think it was intended to be a work in progress, because I don't think we could have expected everything to be fixed at one go. But also an important thing to remember is that when the constitution is applied in practice, when we get our court judgments, we're actually improving the workings of the constitution and how it benefits us all. So as we start to see more and more constitutional law cases, we're actually seeing an improvement in how the constitution is applied practically.
In my point of view, that the constitution of South Africa, based on their history, it has been effective to a certain point. However, the issue I've got with it, and I think most of us would concur on it, is that our constitution is based on a Western perspective, and it is trying to address an African issue. And that is the biggest issue that we've got with our constitution. Yes, it's a great document, but it doesn't speak to us as an African people. So that is the one big challenge we've got with the constitution currently.
And how would you think the African element could be incorporated? If you could speak to Parliament or the legislators or members of parliament, what would you like to see? What are some of the principles from African customs or from African heritage that you would like to see reflected in the constitution?
Basically, we would need to elaborate more on our customary law and of principle. Because historically we're coming from colonization, and the bulk of our law is based on your common law together with your Roman law. So we need to establish that first to say what law speaks to us as Africans. Why are we not focusing more on our indigenous law and delving deeper into that? Not completely eliminating Roman Dutch law and common law, but intertwining more the African side of our law.
Okay. All right. I like that view. Yeah, because constitutions, and you will hear in tomorrow's tutorials as well, a constitution needs to be drafted specifically for the country. It is one of those unique things that needs to actually take the country into consideration, the workings of the country, the population, the history, and all of that. So it is quite a unique document that needs to take into consideration its people. So that is a very good point, Tato. Thank you for that.
So I think, and this is just my opinion, I think the fact that the Constitution is based on eradicating all the injustices from our history is so important, because how would we know what to fix if we don't look at what is wrong? I think all the time, because the Constitution was drafted in a period of, I think, 4 years. So that tells me that there was so much thought put into it, and that every law and every right in the Bill of Rights, every law in the Constitution was specifically looked at so that all different groups in our country can be catered for. I think the problem that we have is it's not that the Constitution does not provide rights that protect us from injustices. The problem is that there are always people who act unjustly towards those who are lower than, and that causes a problem. Now, the other problem that we have as society is that we do not know our rights, and therefore we do not exercise them. That speaks to the effectiveness. The law can only be effective if we know our rights and we exercise them. If someone causes an injustice, you have to stand up for yourself. As a community, stand up for yourself and for the community as well. And that's where the aspect of Ubuntu comes in, and that speaks to the Africanicity of our law. Ubuntu is mentioned in most of our law studies, because that is how we eradicate injustices. The law is there, but we need to do it, we need to access it, and as communities, we need to stand up and we need to use the law to our advantage, because it's better for us. As we do that, the law becomes more effective, because now it's being practiced. When it's practiced, it's more well known. Do you understand? So I think that is the only problem. Also, where I would say our mistake is in our law is the fact that I believe the law protects criminals so much. Something as something as simple as innocent until proven guilty. I think with major common law crimes such as murder, rape, whatever, I would say guilty until proven innocent. The reason why is because the law protects criminals so much that people do not trust the law anymore, because we report something, 5 days later the person is out on bail or whatever, because they also have rights. But I think if you infringe on the rights of others, your rights need to be taken away until we've decided that, okay, you actually deserve those rights. But that is, yeah.
Wow, you have said a mouthful. So many good points there. And one of the important things I think you've mentioned is actually the law being in practice, the law actually working in practice. And that's a point that I wanted to mention as well, to say that it doesn't help having a constitution if it's not exercised. So you really encapsulated that very well, to say that it doesn't help having laws if you're not exercising them, or if you are ignorant or oblivious of the rights that you can actually exercise. So in order to have a properly working constitution, people need to know their rights. They need to know how their rights are going to be exercised, and they need to just have that insight. Yeah, hey, the the guilty until proven innocent one. Yo, that's a tricky one. At the end of the day, the Constitution seeks to protect all persons, and what we need to remember, you'll do this in Fundamental Rights or Bill of Rights. When you go to Section 36 of your Constitution, which forms part of the content relating to the Bill of Rights, it provides for the limitation of rights. So it provides for how rights can be limited, and this obviously has to be in accordance with law. It has to be reasonable. But for example, you've got, freedom of person. You're supposed to be able to move around. You're supposed to have your liberty. But when you get arrested, your rights are being infringed upon. So that is a classic example of Section 36, where your rights are limited, but they are limited in accordance with law. So what the Constitution strives to do is to protect everyone's rights, but at the same time, it has this protection mechanism where people's rights can be limited. And the issue with having guilty until proven innocent is that it would be a serious infringement of rights. And yeah, in any event, how would your court case work? Because you'd be working backwards from establishing guilt without evidence. It honestly wouldn't be fair on the accused person. And another issue that would arise there is that where someone has, for example, been falsely accused, then their rights, their liberties would be infringed upon before they're actually able to demonstrate that they did not commit a crime. So there are many nuances surrounding that, surrounding criminal law itself, just surrounding the rights. But I do get your point that we do have rampant crime in our societies. And yeah, sometimes it feels as if the police are not doing enough. It feels as if justice is never seen. It feels as if bail is just being granted left, right, and center. But at the end of the day, society, we still need to uphold certain rights to ensure that we've got a properly working administration and executive, just in terms of fighting crime. But very, very, very impressive points that you've raised there. Something to think about, colleagues, what she has said in terms of our constitution and how effective it is. Yeah.
I just want to ask you a question based off of what you just said, right?
Sure.
The point where you said we're working backwards. If we work with guilty, then you prove innocence, right? But to some extent, let's just pretend we're in a world where a person cannot be falsely accused. Let's say there's a specific criteria towards it, where you are proven guilty from the get-go. Like, let's say they say, if these actions match your criminal intent and everything, then you're guilty, right? You're caught on the scene and everything. And then it gets to where now you're like, but that wasn't me. Let's say you have a doppelganger. But in that instance, it's like, now we're working backwards as well. The person knows they did it. The legal team knows they did it. And everybody around you knows they did it. But now, as the prosecutor, you're working backwards because it's like, everybody knows you did it. So how is it that in that method where we prove you're innocent instead of guilty is working backwards? Because it's just the same as now.
Yeah, it would just be the same as now. I mean, if there were safeguards that could be put in place to ensure that people's rights are not infringed, then I'm sure it could certainly work. I mean, it's just how the law works, and you'll see it in other aspects as well. For example, civil procedure, where you have to follow the defendant in order to sue them. So it's all in the element of whoever is alleging it has to prove it. That's how it works. But yeah, in a society where there are safeguards that would be applied to guilty until proven innocent, perhaps it could work. Perhaps it could work. It's just that the infringement of rights is so great that it would be unjust on a person to be assumed guilty before the law actually takes its course and determines by way of evidence that is placed before the court that a person is actually guilty. But I think if there were safeguards to ensure that rights are not infringed, then perhaps it could work. Perhaps it could work, because I think we need to look at the prejudice that is suffered by a prosecutor having to prove a case. That is their job. So they're not necessarily suffering a prejudice by actually proving their case. But if you assume that someone is guilty before there's evidence that is actually led to confirm that, then you are arresting that person, you are infringing on their right to actually be free, their freedom of person. Yeah, it's an infringement of their rights as well. So everyone has rights, unfortunately. Even accused persons have rights, even arrested persons have rights, even convicted persons have rights. So that's how our society works. So yeah, to answer your question, yeah, working backwards would work if there are safeguards to ensure that rights are not infringed, because I think the way that it is done now, the method or the logic in actually proving someone guilty is to ensure that their rights are not infringed until there is sufficient evidence to demonstrate that they are actually guilty.
All right, thank you.
Sure. Okay, thank you. That was very engaging. I'm loving the questions. I'm loving the input. I'm loving the comments. We do have 15 minutes left, colleagues. We are at the end of our session. Do you have any questions in terms of the content that we've gone through today? And just bearing in mind that this was an introductory tutorial, so some of these concepts that we've raised today, we are going to be going in depth. For example, tomorrow there's quite a bit on the concepts that you need to be aware of with respect to constitutional law. So this was just an introduction and to just get you into understanding what the module is about, what we're going to be dealing with, and just to give you a taste of what is to come. So do you have any questions on the content that has been raised today, or do you have any other questions in terms of the module?
I'm really having a difficult time with the module. Okay. So I don't know how to put this, but when there's a question, and then it requires me to introduce the branches of the law, maybe how do I see, how do I understand I have to have an understanding of the branches of law, but how do I say, how do I even analyze the question to understand? Maybe it's talking now about the rule of law, now it refers to the constitutionalism or whatever. It just gets too much. Like I don't even know what I'm looking for.
Yeah, so I think that the most important thing, and this goes with all your other modules as well, is to break up the question. So, for example, if they're asking you to elaborate on something, it's always good to firstly start with the definition and then go into sort of characteristics of a principle. If there is case law that is applicable, then you apply it. If you are given, for example, a problem question, where you have to give sort of legal advice or give a legal answer to the question, you must firstly identify what the problem is. Then you would go into which laws would be applicable. So, for example, here, if it's a constitutional issue, then you would indicate that section for example, 172 of the Constitution would apply to this, and then you would apply after that. So you would apply what principle or whatever section you have cited. So, for example, if we ask you limitation of the Bill of Rights, for example, if they say, for example, someone was arrested, is this an infringement of their rights in terms of the Bill of Rights? Then you would go to the relevant section of the Bill of Rights and you'd say every single person has the right to their liberties. They are entitled to move freely as they please, but this right can be limited in terms of section 36 of the Constitution. Section 36 of the Constitution provides that any rights in the Bill of Rights can be limited to this extent. And then you can say, for example, the person being arrested, it's appropriate to infringe their rights because in terms of the Criminal Procedure Act, for example, or in order to solve a crime, we need to arrest a person, we need to take them in for questioning. So it's about just breaking the question down. And then if you have a case that you can actually use to answer that question, then you can use that case to elaborate further. So it's firstly about determining what section of the work is being asked. Then you will go to the relevant legislation. For example, here the Constitution. You will indicate the relevant part of the Constitution. Then you will apply. So go to your sources. Well, firstly understand the problem. Go to your sources and then apply. That's how you should typically be answering your questions, especially at this level as a second-year student. I don't know if I've answered your question.
Thank you so much.
Okay. All right. Yeah, but I think the major part of it, colleagues, is understanding the content. So as soon as you understand the content, you're able to apply it. But if you don't understand the relevant principles, if you don't understand parliamentary sovereignty and the question comes up, obviously you're not going to be able to answer. If they say distinguish between parliamentary sovereignty and constitutional supremacy and you don't understand the underlying principles of those concepts, you're not going to be able to answer. So it goes with understanding the content first, and then you will be able to apply, because you cannot apply what you do not know. So understand the various concepts. The good thing with constitutional law is that it's one of those modules that has a lot of concepts that you can learn and apply. That you can understand, things like separation of powers and all of that, various branches of government, what they do, checks and balances. So it's actually things that you can learn, understand, and easily feed back as long as you understand the relevant concepts. So always bear that in mind, that understanding is key. Understanding is key. If you don't understand the concepts, you can't apply them.
I think that's where the problem is. I just cannot link maybe the separation of power to any constitutional question. How do I link? How do I make? I don't know.
How do you reference?
Not
so that
even, I understand. I understand how I should explain what is being asked, but introducing now what the I don't know, Nkosi yami.
Yes.
Okay. Last semester there was a question about non-compliance, right? And now I explained what non-compliance is. Now I have to put it in constitutional law. How does it resonate? How does it fit together? How does it link? Why are we even having the question of non-compliance? And then when I ask around after the exam, I have failed now. No, Kaloku, non-compliance is not adhering to the task, ne? And then the question was the lawyers came in late in the court case, and then How on earth should I have thought about the rule of law, that no one is above the law, no one should do what not, because of the fact that they are lawyers, they can just come in late.
Yeah.
How on earth?
Yeah. No, sometimes it is. No, I understand what you're saying. Sometimes it is difficult to think of certain concepts when you're answering the question, and especially where the lecturer expects you to, for example, refer to the rule of law in that specific question and you haven't referred to it. But I think the lecturer will be giving you kind of guidance on that, guidance on how questions should be answered. When she asks a specific question, how she would like for it to be answered, the things that you need to reference. Yeah, because sometimes it's not easy to immediately think that the lecturer would like you to address a specific concept when the question doesn't really guide you to that concept. But again, I think it's just a matter of understanding, firstly, and then also during the lectures, some of the examples do come up. So they'll come up in a different way, not in the way that they'll be asked in the exam, but they'll come up in a different way. So if you are focusing and you understand how the example has been applied during a lecture or during one of the tutorials, then chances are when the question comes up in the exam, you will be able to link specific concepts and you'll be able to identify what the lecturer would like to see. But also, I'm hoping that we'll have enough time at the end of September to actually do some revision. Then maybe we can go into how to answer questions, what the lecturer is expecting when questions are asked, so that you can just have an idea and you don't just walk into your exam blindly. Basically, you know what they would like you to answer. So we'll try and do that if we have enough time, but that's provided that we finish all the course material in time, and then we can maybe do a revision. Yeah. Thank you for participating. Thank you for listening. It is an exciting module. So I'm hoping we can continue to engage with each other and we can continue to learn from each other, because I'm also learning from you. When you ask questions and when you make comments, I do learn from you and I get a different perspective. So please continue to engage. And I will see you in tomorrow's tutorial then. It's going to be a long one, so please be on time and please pay attention, because it's quite an important one with important concepts. Thank you.